It's moving. We're in co-ownership.
Yes. Then we're talking about the co-ownership today. Um, we have already gone far now because now we are in the co-ownership. Then ownership, co-ownership is the same. We have been studying about co-ownership for a very long time. We started with the MRL 2601 when we're doing the partnership, uh, and we learn much about partnership. And there is no a difference between a partnership and co-ownership because those two people are doing the same thing. Even the marriage in
Mm.
community of property is part of a co-ownership. So here in this school, you will be discussing the two different types of co-ownership, whether we have a free co-ownership and bound co-ownership. I remember one of the questions where we asked about the free co-ownership and the bound co-ownership, and they said that if the people are married in community of property, are they in the free ownership or are they in a bound co-ownership? And I remember you answered and said that they are in the bound co-ownership. I don't remember whether it's you or whether it's someone else, but I remember doing such a question. No, it
No,
was a question.
we did do a question.
Yes, and we talk about the bound co-ownership. So it means that the bound co-ownership can exist when there's a contract about those people, and the free co-ownership maybe
Sorry,
it
please
can.
hold for me.
Sorry, I didn't hear that what you were saying. So okay, let me go on. So co-ownership, remember it exists between two people or more. So it can't exist between a only single person. So it should be between two or more people who share the same thing in undivided shares. So it means that when they separate, the shares must be divided. So those two people, like for example, they are in the partnership with two people who partner in the law firm. It means that those people own everything, the assets that belongs to that law firm. When now they want to separate, it means that they have to sell those shares. In the community of property, when they divorce each other, now everyone must take half and half. And then another thing that you must know, which is important, is that we have a free co-ownership and co-ownership. Those are the things that you must know. And I've already told you that the free co-ownership is just me and you. Then we decided that we are going to be co-ownershiping for a particular cause. Then we go and co-ownership. But a bound co-ownership, and you're the one who answered, and I said that it only exists when there's a legal position, or such as when people are married in community of property, when there's a partnership which arises based on the contract, and then we can say that there is a co-ownership. And then you must also know note down that in the co-ownership, we do not say that asset belongs to that one, that asset belongs to. They jointly own the shares. So they jointly own undivided shares. It's only when they are separating that some will take 40, 50, and some take 50. Or they can take shares based on the the contract that they sign in when they get into the whatever co-ownership. For example, in the marriage, if we sign a prenups, it means that when we divorce, someone may get 30% and I get 70, or someone may get 60 and I get 40, depending on the contract of prenup. And then business partners and all those stuff, they are part of the co-ownership. Mm, the thing that you must know, are you still here? Hello?
I think she's lost because I can hear you.
Oh, yeah, she's still here. So I think that she has switched the mic. Talk also. Hello? So they said that it should be borne in mind when I were talking about the alienation, which is sale, and they made it clear that if people are co-owners based on the contract, such as marriage, of course you cannot alienate. And I've already told you many times that if you are married in community of property and someone sell your spouse sell the property, you have the right to vindicate such a property because according to but matrimonial act you have to consent. So when there is no consent of you, therefore the alienation never took place. So even here, when there is no consent from both parties, then we can conclude that there is no alienation. So the single person cannot consent to the sale of properties or assets. They must both consent. And when we comes to the use, they must all both usually use the same thing equally and in a reasonable manner. And they are therefore all of them they have a right to use their thing as long as it is in the reasonable manner. And even the profit, income, or fruits, they have to share equally because they are co-owners. So everything they have to share equally. I think this one makes sense. And even to the maintenance and expenses, they have to be the one to maintain. Maybe they will sit down and come up with a plan on how to maintain. And then we're talking about undivided shares. And they say well, X and Y, which is to divide their farm water pot into units where X will use certain parts for sowing crops and Y will use other parts for grazing purposes. And then they say that every free co-owner can make completely independent arrangements with regard to his or her own undivided share in the ownership of the thing. This every free co-owner may alleviate, mortgage, burden with a personal servitude. Remember, we are talking about a free co-owner. We are not talking about a bound co-owners. That is one of the things that you must be
Okay.
able to know. A free co-owner can make a completely independent about their independent shares because there is no legal, they are not bound by the contract. Therefore, they are free because they are free co-owners. However, when we come to the bound ownership, is different. There is a legal relationship. So, such as marriage in community of property or a partnership. Therefore, that person cannot be make an independent arrangement with regard to undivided share. So, if you go to examination, you have to differentiate between free co-owner and bound co-ownership. So, free co-owner because they are freely to make their choices, they can make a completely independent about their undivided share. However, if you are bound by the contract, then there's no way that you can make such arrangement. And then free co-owner can use their undivided share. They can alienate anytime. They can use it as long as it is reasonable. And they can even use it as a sole owner because there is no legal relationship. However, it's different when we come to the bound co-ownership because there is a legal relationship. So when you come to this question, you must always think of people who are married in community of property, and you think of those that are cohabitating. It would be much a good example. So if you come to this question, bound co-ownership are those that are married in community of property, and don't free own free co-ownership are those that are married. They're just that are cohabitating each other. They're just that cohabitate. So it will be very much simple. If you cohabitate, you can just wake up and sell your house without even talking to your partner. But when you are married in community of property, you cannot do that. So this third unit, you just have to use those two cohabitators and those that are married in community of property. You will able to answer all the questions freely here. There is no any questions that you will find it very hard. All the questions when you are asking the examination, you will answer them very well. You must know that there's nothing that cannot be terminated, and you must also know that there's nothing that has no remedy in the court. So whatever you provide such thing, you must always think of the remedy and the termination, because whatever is there can be terminated, whatever it can be remedied. So here, when we come to the division, the termination, if people are cohabitating each other, when they are no longer in love, they can just agree that, okay, I'm taking mine and you take yours. You take yours, then that's it. Or they can just say, I keep whatever I gave you and I'll keep whatever you gave me. Then that's all. So it's up to their how they agree to divide their shares because there's no obligation, there's no legal obligation. However, when we comes to the people who are bound by the bound co-ownership is different. That people will have to, some will have to go to courts, approach the court so that their shares can be divided. So the termination of the community property will always be terminated by the court order. So the court is the one that can order divorce and then terminate, and then their shares will be divided. Or number two, they can be terminated by death. Death is always there in the termination. Once the other spouse dies, then the shares must be divided, or the assets must be divided, or the estate must be shared. Then we go to number 5, we talk about the remedies, and then remedies that are here, you must know that interdict will always be everywhere. That is the only remedy that is applied everywhere because this remedy is only being used when the one right has been violated. For example, in community of property, if the other spouse is selling the house, you can approach the court to interdict such a sale, saying that I've not made my mind about the sale, so I'm interdicting the sale. So as the other spouse, you have a right to do that. So interdict will always be useful everywhere. That's why they say a co-owner can use an interdict to prohibit another co-owner from making unreasonable use of the property. It's the same thing that I was telling you, that if the other spouse is selling the house, you can apply to court to interdict such a person, the sale of a house. Then another one is the damaging, they call it a division of profit. You must know this one only applies to co-owners. So it means that besides interdict, that we will not be saying that, which is very applicable to all scenarios, we can say that the remedies of a co-owners is the damage, is a subdivision. Those are the only two. However, we can even add interdict as a number three. So don't forget when you go to examination, these are not the remedies. These are not the remedy for damage or remedy for property. They are remedy that are only exclusive to the co-owners. So it's very much important to differentiate. Yesterday we talked about those remedies, but those one apply to the person and the other person, individual versus individual. But this one applies to co-owners. So it's very much important to differentiate those one. And this one called damage is when the other co-owner has used the shares in a reasonable manner, or in a way that it was not in accordance with how they must use the share. So the other party can apply the damages or the division of a profit as a remedy so that the shares can be divided. And if that one is used unreasonable, it means that they will take some portion of the each share and then they will give to another party. And then we have subdivision. To subdivide their property for any reason, then they can go and agree that they want to subdivide their property. If now the relationship between maybe them is no longer amicable or it's no longer healthy, then they can go and then they subdivide their shares. And they say that the applicant must show that he or he has already tried to obtain a division by means of an agreement with the other co-owners. Only when such an attempt has failed can a co-owner approach the court. So today we were talking about the co-ownership and we have already finished. We talk about the termination, we have already finished, and now we are going forward. Or you have a question regarding this?
No, I'm fine.
Oh yeah. Now we are coming to the study unit 8 where where you were asking questions of yesterday about the ownership and possession when we were talking about malafide and bona fide. It's very much important to know this one about the
Okay.
possession and about the ownership. There's a difference between possession and ownership. So it's very much important to differentiate when you go to examination. And they say that Q accidentally sinks a borehole on the farm belonging to X and Y, and erects a windmill there. He was under the impression that the borehole had been sunk on his side of the boundary, and they said that S leases 100 hectares of a waterford from his parents, X and Y, for grazing purposes. The lease contract is invalid, and S is aware of this until his attorney is unaware of this until his attorney informs him of the invalidity. So you must know we have already talked about it back then. We said that a person who's aware that the lease agreement is invalid, but he keeps on being there, is called malafide holder.
Mm,
But
mm,
the person who is not aware that the lease contract is invalid, that person is called the bona fide holder. So it's
mm,
very
mm,
much important to know those two kind of relationship. And then you must know that this S, when he was not aware, he was a bona fide. Then now when he knows, he's a malafide because he knows very clearly now that I'm not allowed here, but he keeps on staying. And they said, S opens his mail and finds pornographic material in it. He decided to take it to the police the next day on his way to work. In the meantime, he hides it high up in a cupboard in his bedroom so that his wife and children will not see it. That night, the police raid his house and discover the pornographic material. S is charged with the possession of pornographic material in terms of the Indecent or Obscene Pornographic Matter Act, which prohibits possession of such material. Then, when we talk about such a thing of possession, we remember when we were doing CRW 2602. If you could remember, we have done about the possession, which where they even give example of the dagger. Some people using a dagger, some were found with the cocaine, some were found with different types of drugs. And I believe that you remember when we read about such a thing in the CRW 2602. I believe you remember we dealt with the
Yes.
possession of a dagger and all those things.
Mm, mm.
Yes. And then we remember back then when we talk about the two elements, and we said that we have a physical and mental element, and then we said that physical
Elemental
is corpus
element.
and mental is animus. I believe that you are
Yes.
still remembering.
Yes.
So they said here that the possession which we read earlier, they said therefore possession in a broader sense can be described as a real relationship between a legal subject and a thing, characterized by two elements, the physical element and mental element, the corpus and the animus,
Mm,
meaning that the person can
mm.
be in control of that with the mentality that is the owner. Depending on the content of the mental element, this relationship described as a possession, which is always unlawful, or holdership, which can be lawful or unlawful. Physical control with the intention of an owner is possession, but physical control with the intention to derive a benefit is a holdership. And we have already talked
Yes.
about this one, and I know that we are repeating the same thing. So it means that if I come and live in your house with the mindset of sheltering myself there to derive a benefit, it means that I will always be
It's a
a
hold.
holdership.
Oh,
Then
holdership.
meaning that if
Mm.
I don't pay a rent and I'm aware that I've never paid a rent, of course, then when I didn't pay a rent, it means that I'm malafide holder because I'm deriving
Yes.
benefit whereas I have not paid for such a thing. Then when a lease
Yes.
agreement has expired and I keep on farming on the farm, it means that I'm deriving benefit and therefore I'm malafide holdership. So it can be
Yes.
lawful or unlawful, this one.
Okay.
And
Mm-hmm.
then lawfully is when if I written on
You
the
are not
will
aware
that
that the contract ended, no?
yeah, that's unlawful holdership. But lawful holdership is when now I know that I've signed a contract. When I die, I signed a will that my wife must stay in the farm as long as she lives. So it means that I've given such a person a habitation, the right to habitation. So such a right to habitation is called a lawful holder. So it means that my wife is a holder ship, which we call my wife a holder ship of a such a property.
Yes.
Yes, that's when it's lawful. So it means that it can be lawful or unlawful, but possession is always unlawful.
Mm.
And then physical element, I've already told you that is the physical control of such a thing by the possessor. Meaning that if I'm renting here and I didn't pay a rent, of course I'm physical controlling the room that I have not paid. So it's called a corpus, it's a physical element. So it means that I'm exercising my rights on that by physical controlling such a thing. Then they said that's a direct and it's indirect physical control. However, it is not important for examination, and you will never find a question stressing you about such a direct or indirect physical control. Therefore, even if we read it, we'll be wasting our time. And then acquisition of a control, and then they give example by S and his friends go for hunting weekend. S mortally wound a kudu. The kudu managed to escape. We have already dealt with this one. We won't repeat because
Yes.
we even applied the remedy spoliator, and then everything we have already covered in this one. So this one was
Yes.
very easier because it's things that we have already done. All of those things, even if we go to continuous, we are still going to do the same thing. So all those things that are here, we have already done it. And then the mental obvious. When we talk about animals, we know that we're talking about the intention. So the person intention here is there, but you won't find this one in the examination. They won't ask you about the intention of a person because they believe
Okay.
that you deal with the intention when you have been dealing much with some modules. So the intention here is not important on the property. So they won't ask about the intention of owner. However, if you find a question about the intention of owner, you can actually come to the intention and find right here. Then I've already told you about bona fide possessor. We won't repeat this one. And malafide possessor, we won't repeat this one. We have already lawful holder. We've already talked about lawful holder, and I've already told you about the person who has a right to habitatio. And they even give the example by the tenant, the person who's renting, who's paying each and every monthly, a borrower, a pledgee. Then unlawful is the same thing. Can be a bona fide unlawful holder or malafide unlawful holder. And yesterday you were asking about whether you have to be mentioning a holder, and I said that is not important as long as you can mention malafide. However, in some circumstances, you can actually mention that it's a bona fide holder or malafide unlawful holder. This question will always be an examination asking about the relationship with such a thing. So it's very much important to know about bona fide, unlawful holder, malafide, lawful holder, the lawful holder, and unlawful holder. However, we have dealt with much of these questions, and I hope that in the examination you will be knowing this one. And then possession. This will never see an examination, so studying them will be wasting our time. It's the things that will never be in the examination. Even if we study those things, we will be wasting our
Mm.
time. So we have already dealt with many because we have already dealt with them back then. Then we just have to be going forward. And then we are coming here to the possession, holdership, protection, and termination. And then when we started, it's very much important to be here so that we do not even
Mm-hmm.
waste our time because it's something now here we talk about the remedies. We have already know about the spoliation remedy. We have already talked about the spoliation remedy. And then I hope that you understand very well about spoliation remedy. And we give example by the someone who was removing the condenser, and then we said that this one wants to check who is the who acquired the ownership. So spoliation will be a good remedy where people where they say where want to prove that you are the one who acquired the ownership. So it you know now that if it is the question of ownership, then you can apply spoliator. Then we have already talked about the spoliator, and then conditio futiva. That one we have already talked about it, and I remember that we talked about it so well yesterday. We were there, but I know that you have forgotten. But you said that you will visit, right?
I'll reread them
Oh
because
yeah,
when
and I
I reread them, it will make sense.
oh
It's just
yeah.
because of the expressions that are not common.
Oh, okay. Then declaratory order, we are just mentioned to you that is when there's a legal dispute regarding the position of such an ownership or such a servitude. Then they always go to court for declaratory order. Interdict is still the same. I've already told you about the interdict and how you see the interdict. Aquilium action, yesterday we talked about it, and I know that you have understood and I said that is when there is a claim for personal loss. So, for example, if your car has been damaged, you use the Aquilium action. But if has been your car is in the hands of another person and you want to take it back, you use vindication. However, if it is damaged, you use the Aquilium action. Then that was a, a, a that was simple. Even here in the declaratory, they say that they can apply for a declaratory order to determine whether the right to use the stand. I've already explained to you that if the person wants to determine the ownership or the servitude, then the spoliator is this one that I've already told you that they want to check. Is applied when they want to check who acquired the ownership. And then as well this one, then we go to which one? We are still on the spoliator. Uh, then when we talk about the possessory action, we have a given example that when you apply the spoliator, you must know, you must ensure that such a thing is still existing. Do you remember?
Okay.
Yes, it's still existing. So it should be identifiable, that thing that you're applying for. So they should be
Yes.
identified in it. It's a kudu. They should be identifying such a kudu. So now, if the house has been burnt down, it's no longer identifiable, for example, then it means that now you use the possessory action, which will be used if a spoliator is not. So this one will not even waste our time because in the examination, there won't be a possessory action. There's no question that will come asking about the possessor action. So reading it will be wasting our time. There's no question that will be a possessor. That's why they said that where the spoliation remedy does not apply, then they can use this possessor action to recover control of a claim that has been damages. So yeah, and then condition futiva is the one that we have already discussed back there, and you said that you will visit those remedies of a condition futiva, and I said to you that that one arises when there's a theft, right? And then this one already explained many times. And enrichment action, Yesterday we talked about the enrichment action. I don't know whether you are still remembering or when we were talking about alien. Do you still remember? Where we said that nobody can be unjustified enriched. And we opened some of the questions that deal with this one. So this one specifically deal with the unjustified enrichment and can be applied where there is a unjustified enrichment. And then if you want to answer that question of yesterday, it means that you will have to use a unjustified enrichment. That one, that question that we're dealing with for yesterday. So for example here, let's do this. Are you still here? Let's open this.
Yes,
Oh
I
my
am.
gosh.
Sorry, yes, I am.
Oh my gosh. So unjustified
Can you hear me?
enrichment, yes, justified
Oh, okay.
enrichment. Let's do this. Let me do this one. Let me open this question paper. Oh yeah, let me come up with this question paper when we talk about a justified enrichment, because it's one of the papers that is very, very much important. Let's go down. Yes, this question is that Olani owns a VW Golf. His friend John borrows the motor vehicle and is involved in a motor vehicle accident. John takes the motor vehicle to Auto Magic Panel Beaters. Auto Magic Panel Beaters informs John that the cost of the reparation amounts to 30,000. John is unable to pay this amount to Auto Magic Panel Beaters. Can Olani vindicate his motor vehicle from Auto Magic Panel Beaters? Substantiate your answers in full. You can see this question, right? And then yesterday we talked about this one, and I said to you, yes, Olani can able to vindicate the car since it belongs to him. However, the panel beaters will apply enrichment action. In terms of an enrichment action, the panel beater will recover compensation for unjustified enrichment from Olani of the improved thing. This action is based on the principle that unjustified enrichment should be compensated. Unjustified enrichment takes place when one person improves another person's things without a legal cause, e.g., contract. There was no contract between Olani and the the panel beaters. However, no one can get rich by in the expense of another person, so that the owner of the thing is enriched at the expense of the prover.
Hello?
So it means, hello,
Hello?
yeah, I can hear you.
I was cut there for a few seconds now. I was cut there. I think it was for a minute. I couldn't hear anything at all.
Oh, you are back now.
Yeah. Yes, I'm
Okay.
back now.
I read that question of a Kolani, and now I'm answering. And I
Yes.
said that Kolani can able to vindicate the car since he's the owner. However, the panel beater will apply enrichment action, and then it means that the panel beater can recover compensation of 30,000 for unjustified enrichment from Kolani of the improved thing. This action is based that nobody can be enriched. Unjustified enrichment should be compensated, meaning that nobody can get rich in the expense of another's. And then
For
it means
another
that the
person. Yes.
person can get his enrichment. This enrichment involves when there's no legal cause, meaning there's no contract. We apply this in a legal remedy, meaning that there is no contract between Xolani and the panel beaters. However, there is a contract between John and panel beaters, but John is not the owner of the car. Therefore, the contract between Xolani and panel beater never existed. However, the court can take action, and the able panel beater can take action through enrichment action and able to recover the 30,000. This is based on this case of a Buzzard Electrical. Then now we understand this one, and they talk about the essentials, and they talk about the useful, and they talk about the luxurious, which is not a the important thing to know. Then they talk about the termination of possession and holdership. And I have already told you, we have already been learning about the termination today. And I told you that the termination,
Yes.
it can be either the death, the destruction, and the termination of legal relationship. So there's no way that we can repeat this thing because we have already learned from above how they terminate. So it's just the same thing. No matter how question can be asked, the termination will always be the same thing. That's why even here on this study guide, they only written one